or what that could mean in the context of an interaction with certain public officials, especially police officers, that really does not capture the essence of all the concerns that can flow from a person exercising these rights, depending on the circumstances of the stop or the arrest or something of that nature. Glick was very clear that there could be legitimate time, place, and manner restrictions placed on the exercise of these rights. And the facts of the Glick case were specific. In that case, the person who was doing the videotaping was approximately 10 feet away from the action. The court characterized that as a comfortable remove from what was going on in the case, which fed into the court's decision to find that there was a protected activity here. Just to give you another case as a comparison, there's a 2012 U.S. District Court for the District of New Hampshire case, and that, I don't know how to pronounce it, but it's Bleish, B-L-E-I-S-H versus Moriarty. And I don't mean to oversimplify it because the analysis in that case also hinged a lot on the validity of a disorderly conduct statute. But in terms of what the person who was exercising their rights did in that case, you had certain facts like the person doing the videotaping was within 2 feet of the officers in question that remained in the street after repeated orders to vacate the street and to give more distance between the videotaper and the cruisers. The individual that was doing the taping actually put the camera in one of the officers' faces within less than a foot of the officer's face, and at one point actually reached into the cruiser to do some of the videotaping. So you'll notice in all of those facts, again, there is no actual physical touching going on. So depending on what meaning a person wanted to give to physical interference, I think this bill, if it were to pass, it would be better if more clarity were imported into that phrase. And then the last thing is that that the bill, as it's written, and again, the Deputy Attorney General Ann Rice mentioned this, the non-government officials, the citizens who are the other participant in these transactions, there's no recognition for any rights that they may have, any intimidation that may be going on, any private information that may be developed or given to the government in those transactions. And just in closing, again, there was an example of a DMV worker. The folks at the counter, when they're doing transactions with members of the public and giving out licenses, registrations, all of that information that gets developed is restricted under the Driver Privacy Act, and the public's right to have that information is very, very limited, and it certainly would compromise that aspect of how the state does business and how people expect their information to be treated by the state if a person could stand there and videotape these transactions. I'll do the best I can with questions, and I do have a card for Commissioner Sweeney also.
Representative Valencourt.
Yes, I was going to ask you that